Hello and welcome to the Patent Pending Made Simple podcast. I'm your host, Samar Shah, and with me is Jamie Brophy. Jamie, how are you?
Hey, Summer, I am good. So before we get started on today's super exciting topic, I'd like to do a shout out to a dedicated listener, if that's okay with you.
Yes, we love shout outs on this show, and in particular, this particular shout out. So yes, let's hear it, Jamie.
Yeah, so I want to give a shout out to my mom, Donna. She listens to every episode, and she always calls me after to let me know that she listened, and we talk about what she learned. So hi, Mom. Thanks for listening. We appreciate you.
Yes, hello, Jamie's mom. Thank you for listening. You know, Donna has already proven herself to be a dedicated listener, and even I know this, Jamie, because we had set up a little hotline for people to call in and leave questions or leave a review. And Donna was the first and the only person so far to have called in and left us a review from the very early days of our podcast launch. So I know she's listening and we are thankful.
Yeah, well, I'm glad to hear that you know about it from the feedback, because if she had your phone number, she'd probably call you too. She's done it before. She's called coworkers of mine before.
That is funny. Well, that actually leads us to our next point is if we've been having a lot of listeners who our listener base, I guess, is growing and it grows every week. And people have been reaching out to me and, you know, just giving us shout outs or high fives and asking questions too. They're like, hey, can you cover this or can you cover that? Or I have this question. Can you guys talk about it? And maybe we should have a formal place that people can send their questions to. We can try to answer them on the podcast.
Yes, that would be great. And we already have some email addresses set up for this so that people can email us to, ask us questions that we could potentially address on the podcast. So if you want to email me, mine is jamie@patentpending.ai. And Summer, I think yours is kind of the same, right?
Yep, that's it. SAMAR@patentpending.ai. I fully expect Donna to be the first person to email us. And so I'm actually looking forward to getting that email.
Yeah. Awesome. Yeah. I'm looking forward to seeing what kind of questions we get.
Yeah, me too. I've been getting lots of really interesting questions and we've been putting a document of those questions together. So I look forward to tackling those. I had a call with one of our listeners a couple of weeks ago and he was another attorney who's been listening to our show. And I was like, yeah, give me some constructive criticism. What can we do better? And he said he'd like to hear more war stories or stories about like how some of these things might have played out with our clients or other kind of industry news, that kind of thing. So I'm always a little worried about talking about clients because, it does get into concerns about attorney-client privilege. We're not allowed to talk about client matters. And even if there are public client matters, I'm still a little skittish about that because I don't like to even get close to that line. But certainly we can talk about what is happening in the cases that we read. We read, legal cases all the time and lots of interesting fact patterns there that we can talk.
Yeah. Oh, great. Yeah, that's great feedback. We can certainly do that.
Okay. Yeah. So we'll try to do that. And why don't we jump into today's topic, Jamie, with some of those formalities out of the way? What are we talking about today?
Yeah. So today we're going to talk about what happens after your patent application gets allowed. And specifically, we're going to be talking about how to determine whether or not to file a continuation application. So I think we've kind of addressed this in other episodes, but once you get a notice of allowance on your patent application, there are some things you have to do. You have to pay the issue fee and stuff like that. But today we're specifically talking about how to determine whether or not to file a continuation. So once your application gets allowed and before your patent issues, you've got a little bit of a time buffer in there. And during that time, you need to determine whether or not you want to file what's called a continuation application. And the continuation is basically the same application. The only difference is that the claims are different. So Summer, do you want to talk a little bit about maybe add some more detail about a continuation or talk about some reasons why you would file a continuation?
Yeah, let me just talk about the continuation as an application. So you're right, it is the same application as the parent application, but it has a different set of claims. So ideally it has a different claim scope than the parent application, but it actually shares the same priority date as the parent application as well. So you could file a parent application, let's say in 2020, and that patent gets allowed in 2024. You could file a continuation application in 2024, but that 2024 2024 application will get priority all the way back to 2020. So the nice thing about the continuation is that you can file new claim matter, but have it be dated back to your original application. So that's the reason you'd want to file a continuation as opposed to a brand new application, is because you can get that old priority date, which is sometimes important. The only caveat is that whatever you try to claim in your continuation application has to be disclosed and be supported by the specification that you drafted in 2020. So that's, hopefully that kind of gives everybody an understanding of why you would go down this road in the first place.
Yeah, and just to clarify and back up a little bit, that original application is considered the parent application. Samar, I heard you use that term a couple times, the parent application. And then the continuation could be considered a child application, or any continuation could be considered a child application off of that parent application. So yeah, I think that kind of covers it for exactly what a continuation. And then what are some reasons why you would want to file a continuation?
Yeah. Oh, and one more thing. Sometimes inventors will hear the term divisional application as well. Divisionals are kind of the same thing as a continuation. So they share the same spec, the specification as the original or the parent application, but they have a different set of claims. The deal with divisionals is that they usually are bifurcated by the examiner. So if you submit two claims in your original application, the patent examiner or the patent office may look at those claims and say, well, these two claims cover two different inventions, so you had to pick one and we'll only examine one, because the rule is you're only allowed to have one invention per application. So in those cases, you get what's called a restriction requirement, and you have to kind of subdivide your claims, and then you can proceed with one set of claims and then try to come back and capture the second set of claims in a divisional application. So sometimes inventors use those terms interchangeably. They are two separate types of priority applications, but they function the same. And everything we're going to talk about today is going to apply, I think, equally to continuations and divisionals as well. So yeah, both continuations and divisionals share the same priority date, share the same specification, but have different claims relative to the original or the parent application.
Yeah, that's right. And, just to give an example of that divisional you were talking about, Summer, what I run into a lot in my practice area is in that original application, we'll have a set of claims directed to the device or the apparatus, and then we'll have another set of claims directed to the method of using that device. And a lot of times we'll get a restriction requirement from the examiner for that, where, they want us to pick between either pursuing the device or pursuing the method of using the device. So we would pick one, and then we could pursue the other one in a divisional application. We would just take that set of claims and put them in a divisional application. So that's just kind of an example of what we mean by a divisional, but it's just another kind of a continuation application.
That's right. So to kind of circle back on your original question, Jamie, there are a few different reasons to file a continuation, in my opinion. There are some reasons not to file one too, which I'm sure we'll talk about. But the primary reason is to change the scope of coverage that you got on your product or on your invention. So, the claims, as I hope all of our inventor listeners know by now, claims are the legally operative part of your patent application. The claims are kind of the metes and bounds, or define the boundary of your intellectual property. And sometimes you're happy with the boundaries that you were able to get from the patent office. But sometimes you want to change that boundary, right? You want to expand the scope of coverage around your intellectual property, or you want to change it, right? Because the product has changed, or because something else has become important, or you have, your goals have changed, right? You're, instead of selling it as on an e-commerce platform, you're now licensing it to somebody else, or you want to license it to two different companies in two different technology or application spaces. So all sorts of things can change, because it does take a long time to go from patent application to a patent. And if the invention or the go-to-market strategy or any of the business fundamentals that undergird the invention have changed, that might be a good reason to file that continuation.
Yeah, absolutely. And even if nothing has changed, I think if it's within your budget, it's a good idea to file a continuation in case something like that happens. Something like that could happen while the continuation application is pending. And then you at least have that application pending. You can, change the claims however you need to adjust to your situation. But if you don't have a continuation pending, you're kind of out of luck. Once that original patent issues, that's it. That's the deadline for filing continuations. So it's nice to have something pending in case you need to cover a situation like that.
Yeah, I would say that's usually the biggest concern whenever I'm filing continuations for the client. We're usually pretty happy with the scope of coverage that we get, but we just don't know what kind of competitive threats are going to show up down the road, or how the marketplace is going to change, right? So you could be in a kind of a startup-y type of environment. There's a lot lot of small players and you just need to protect one little thing that you're doing. But there could be industry consolidation, right? So like some big company can come in and buy up a bunch of startups, and now you have a very different competitive threat model to deal with. A continuation is great in those circumstances because it can help you size your claims to the threat that you're looking at. So I think you're right. The biggest benefit is the ability to modify things later, because once that patent issues, the claims are set in stone. There's no way to change those at that point. And if you want to retain the ability to change the scope of the claims, you have to file a continuation, and you have to do it within the timeline that you outlined at the top of this podcast, Jamie.
Yeah, that's right. So, and then kind of the converse of that, like what would be some reasons why somebody would not want to file a continuation, Summer?
Yeah, so budget being kind of the biggest thing. It is expensive to file a continuation application. There's usually the government fee involved. There is also the attorney's fees involved in drafting a new set of claims. And usually, once you file that continuation application, the patent office will treat it like a brand new application and they will reject the application at some point. So you got to go through that whole process, and it can end up costing quite a bit of money, right? Or at least half as much money as you spent in your first or the parent application. So you got to budget for that. And that's a kind of a lengthy and potentially expensive process.
Yeah, that's right. I would say, that's the number one concern when deciding whether or not to file a continuation. I had a call with one of our clients recently, Summer, that he had some patents. We had filed a continuation and we were at the point where we got a rejection on that continuation application. So I called him to talk to him about it. He's a small business, so he was spending a lot of money just enforcing the patents that he already had. So he ultimately decided that he didn't have the budget for pursuing that continuation application. His patents were doing what he needed them to do, and he was, wisely spending his budget on enforcing those patents. So yeah, I would say, budget is probably the number one reason why you wouldn't file a continuation.
Yeah. And actually, that example is very illustrative. So thanks for bringing it up, because I think the continuation kind of did his job, right? Because when he was thinking about enforcing his patents against this competitor who was bigger and, potentially could muscle him out of the marketplace in some ways, we didn't know exactly how that competitor might change their product, right? To get around the patent that we had. So there was a ton of value in filing a continuation. But once that competitor went to market, they had also kind of shown their hands, right? Like, this is exactly what the product looks like. And we could look at our original patent and say, yeah, we feel like this one is covered. So we don't need additional claim scope. We don't need the ability to amend claims at this point. And given the budget situation, we could safely let that go. But from my perspective, that continuation filing did its job because it did give us an extra comfort layer and a security blanket, especially when you're operating in an environment where you don't know what your competitor is doing. So you got to have that insurance policy. Sometimes nice to have, even if you let it go later.
Yeah, that's right. So I would say when deciding whether or not to file a continuation, what you want to take into account is, A, your budget, and B, your business goals. It just depends on what your business goals are. I mean, we have a lot of our clients are independent inventors, and, sometimes they just want to be able to say, hey, I have this patented product and they've already got a patent on it. They don't necessarily want to spend the time or money on pursuing another patent on it. So they've met their business goals as far as that goes, and they don't need to file a continuation. So can you think of any other reasons why somebody would want to file a continuation, Summer?
I think that's a big one. I think we covered the big ones. There are a few others, but let me do this. Let me ask you some questions, because actually the reason we're recording this podcast is because this question has come up a few times with our clients, right? And we're like, hey, maybe this is something other inventors are thinking about or dealing with as well. So let me ask you some questions that our clients have asked us about continuations and see if that helps clarify the issue for our listeners as well. So can I take the perspective of our clients and ask you some questions about this?
Yeah, let's do it.
Okay, all right, let's go. So we filed this continuation 2 years later. Now I have received an email from you, Jamie, saying that my application is rejected, and I am super concerned. I thought our patent was allowed, but we got a rejection. What's the deal? Is the patent office changing their mind? And if they are they allowed to do so?
No, the patent office is not changing their mind. You still have that original patent. So the rejection is on your continuation application. And, if you'll recall from 2 years ago when we filed this application, we were trying to obtain some different or broader scope in the claims to give you some more, more protection. So this rejection is for the continuation application, but you still have your original patent that issued already.
Okay, so that patent doesn't get rescinded just because I got a rejection on my continuation application. Is that right?
Correct. Yeah. The continuation is a whole new patent application. And once the continuation issues, you'll have a second patent.
Okay, Okay, great. The other question that we get, Jamie, is why is the examiner being so difficult? He or she already rejected us on this parent application with the same references, and now the examiner is trying to reject us again with the same references. Don't they remember that we overcame the reference and it's actually different from our invention? Well, what's the deal here?
Yeah, so the patent examiner's job is to look at the claims and look at the prior art and determine whether what is claimed is in the prior art. And the claims in the continuation are a little bit different than, sometimes a little bit different, sometimes a lot different than the claims that issued in your parent application. So we've changed the wording around, and the examiner is now saying that these claims that are a little bit different in scope are rejected in view of these prior art references. So Summer, a lot of times we file a patent application. In the first communication we get from the patent office, some of the claims are rejected and some of the claims are allowed. So in that situation, a lot of times what we do is just take the allowable subject matter and, instead of getting into some back and forth with the examiner, that prosecution, every time we respond to a rejection, that costs the client money. So sometimes we just take the allowable subject matter instead of getting into some, response and back and forth. And then we file the continuation to try to claim some of that broader scope. So then we have the patent issued on that allowable subject matter that the examiner originally found allowable. And now we're pursuing the stuff that the examiner didn't find allowable. And that's going to take some back and forth. We're going to have to maybe amend the claims, maybe respond to the rejections with just arguments. So there's going to be a little bit of prosecution history going on. So do you think that answers the question?
Yeah, I think so. I mean, it's hard not to take anything that's called a rejection personally, especially
Right.
if you had to fight tooth and nail to overcome the rejection or spend a bunch of money to get that overcome. And then to see a different flavor of the same rejection again kind of feels like adding insult to injury, right? I think it's important to remember that examiners are prosecuting how many applications a year, Jamie, would you say?
Hundreds.
Hundreds, right? I mean, tons. They
Yeah.
don't remember the specifics of your case. They don't remember the nuances of why this application overcame or this set of claims or this word overcame this reference. They're going to do their job, which is to look at the claims and then to find prior art references that describe similar or same things. So they may not remember the nuances of what you thought about 4 years ago, 500 applications ago, right? Like that's just too much of an expectation, I think.
Yeah, that's right.
Okay, very good. I think that's all the questions that clients ask us, Jamie. Are there other things that they ask us that maybe I'm not thinking about?
I think what you talked about in your first question is very applicable. Sometimes we file these continuation applications. We've explained to the client what the continuation is and how it works. And we file the application, and then it's a couple, 2-3 years down the road when we finally hear something back from the patent office. And by that time, the client has kind of forgot, why do we have another application pending? What's going on here? So sometimes they have the question of, why are we filing another application? Like, I already have a patent on this. Are my claims in that patent worthless? So what do you think about that, Summer?
Oh, yeah, that's a good question. Yeah, it's like, why did we file this? Does this mean my first patent was awful and no good? No, definitely not, right? I think, like we said earlier, the goal of the continuation is to change the scope of coverage. I always kind of think of it as an envelope around your intellectual property. And for some reason, we want to expand the width of that envelope or the circumference of that envelope. And sometimes we want to change the location of that envelope, right? So we want to cover different parts of this process. So sometimes we'll write claims about the device itself, but maybe now we want to capture the method of manufacturing the device, right? That's a reason to file a continuation if you have support the original patent. That doesn't mean your device patent is worthless. In fact, it's still may be the most valuable patent, and maybe the continuation patent is just going after different infringers because you have figured out there's a new threat out there, or somebody's found a creative way to access your benefits by using a different device, but the method manufacturing is the same. So there's all sorts of reasons to file that continuation. It has no bearing, I think, on what the scope of the original patent was, right? They are supposed to be reviewed and they stand independent of each other. You're not supposed to review the claims of one patent in view of the others. That's an impermissible interpretation of the claims.
Yeah, that's right. So yeah, I think think that about covers it as far as whether or not to file a continuation and what the heck even is a continuation. So I think that kind of wraps it up unless you have anything else to add, Summer.
Yeah, I will leave us with a war story since a listener requested one in particular. I have a client where they have a couple of patents and they found a competitor who started infringing those patents. And we sent them a letter saying that, hey, we have patents on this. You're infringing. We'd like you to stop. And they come back and they say, well, we don't infringe because X, Y, and Z, right? And we're like, those are not material differences. That's just like differences in name only. But they really kept pushing back on us. And we could have gone to a judge and filed a lawsuit, and it would have been very expensive for my client and not, worth it given the amount of damages that were happening. But because we had continuations in their applications, we actually just changed the verbiage in our claims to reflect the verbiage that the competitor was using in their marketing material, right? So that if you put their marketing brochure and our claims right next to each other, you wouldn't see a difference, not even in the words that were used. And when we wrote those claims up, even though they were kind of roughly the same claim scope as what we originally had, and we sent those to our competitor, they stopped infringing right away. They probably looked at it and they said, yeah, there's no way to get around this. Like, let's just drop it and move on. And they did. And that was a way cheaper way to resolve the conflict than to have filed a lawsuit. So sometimes continuations can pay off. I kind of think of them as insurance policies. Hopefully you won't have to use it. And, but you just never know, right? That's the whole point of the continuation, I think, is that it helps you deal with things down the road that, it's hard to expect or anticipate today.
Yeah, nice. Oh, that's awesome. That was so smart. Yeah, so the continuation can kind of be, in a way, a deterrent to potential infringers. If they know you have a continuation pending and they don't know what could possibly be in those claims, that could be a deterrent. So yeah, that's really smart. What a great idea.
Yeah. And then the same thing could be true in licensing negotiations, right? So every time, not every time, but a lot of times you enter into a licensing negotiation with a big company, and the big company is going to try to beat you down, right? And they're going to say, your patents are no good. Your claims are too narrow, or it doesn't cover this, or we can get around this, right? And they're just like trying to negotiate you down. And it's so frustrating. Clearly, we're having this conversation because you're interested in my patents, and now you're saying my patents are no good. But having a continuation in place is nice, right? Because then they try to beat you up on your patent, and you can say, well, I can correct those problems in my continuation. It's just waiting in the wings. Go ahead and try, right? So that helps smooth over some of those negotiations.
Yeah, awesome. All right. Well, I think that covers it, Summer. Thanks for recording with me today.
Yes. Thanks, Jamie. And thanks, Donna. Once again, we appreciate you. And if you guys have any questions for us, shoot us an email. We look forward to hearing them.
Absolutely. Okay. Talk to you next time.
Yep. Thanks.
Thank you for joining us on the Patent Pending Made Simple podcast. I hope you enjoyed our show. If you'd like to receive updates, view the show notes, or access a direct link to any resource, go to the episodes page on patentpendingmadesimple.com. To help others find our podcast, please like, share, and subscribe. Thanks again for tuning in. I look forward to having you with us next time on Patent Pending Made Simple. This podcast has been hosted by Outlier Patent Attorneys and is not intended to, nor does it create, the attorney-client privilege between our hosts, guests, or any listener for any reason. The content of this podcast should not be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.